Thank you for taking a break from your regularly scheduled day to attend this special event. Not only is this a book talk, but it's a conversation between colleagues, and we are honored to introduce them both now. I, myself, am Cass Oskowski. I am the co-acting director of our fabulous Daniel F. Cracchiolo Law Library, and it is my distinct pleasure, both as part of the research and writing and instructional team, to welcome you to this very special faculty book talk for Susie Salmon, Director of Legal Writing, Clinical Professor of Law, and Distinguished Public Service Scholar, in discussion with Joy Herr-Cardillo, Associate Clinical Professor of Law, to discuss Professor Salmon's new book, The Moot Court Advisor's Handbook. Professor Susie Salmon is the Director of Legal Writing and Clinical Professor of Law. Professor Salmon's scholarship focuses on legal communication and rhetoric and explores how long-standing practices and values in legal education affect access to justice and bias in the profession. Her recent scholarship also involves theoretical and empirical inquiries into the role dissenting opinions play as precedent. In 2022, the College of Law recognized Professor Salmon as the Distinguished Public Service Scholar, and in 2024, she was recognized with the Leslie F. and Patricia Bell Faculty Service Award. A nationally recognized expert on moot court, who has coached the College of Law's ABA National Appellate Advocacy Competition teams for over 15 years, and who currently oversees the college's internal faculty competition. Professor Salmon authored A Short and Happy Guide to Moot Court and co-authored the Legal Writing Institute's Moot Court Advisor's Handbook, which is what we're discussing today. She also frequently presents to local, national, and international audiences on issues related to legal communication, rhetoric, and advocacy. Trained as a commercial litigator with 9 years of experience at large law firms in LA and Tucson, Professor Salmon remains active in the legal community. She is a past chair of the Southern Arizona chapter of the Arizona Women's Lawyers Association and was recognized with the organization's Margaret Truman Leadership Award in 2023 for her service to the profession. She remains an active member of the Arizona State Bar. Professor Salmon is also a leader in the national legal writing community. She served on the board of the Association of Legal Writing Directors for several years, and she was president of the board of Legal Writing Institute from 2022 to 2024. Just a few small accomplishments for our author for today. And then Joy Herr-Cardillo has taught legal writing at Arizona Law for 22 years. She has been on the clinical tenure track since 2017. After graduating from the UA College of Law in 1984, Joy spent the next 15 years as a commercial litigator in the Tucson office of a Phoenix-based firm. In 1999, she became a staff attorney in the Tucson office of the Arizona Center for Law in Public Interest, where she worked on a range of legal issues, including environmental law, government accountability, public education, and direct democracy. Joy has argued cases in federal and state courts, including the Arizona Court of Appeals, the Arizona Supreme Court, and the Ninth Circuit Court of Appeals. As a full-time professor, Joy teaches 1L legal writing, helps supervise the Writing Fellow Program, supervises the Law Writing Center, and coaches Arizona's environmental moot court team. For the past 3 years, Joy has also served as the chair of the Legal Skills Competition Board, which is made up of faculty and students. The board is responsible for overseeing student participation in the established legal skills competitions, as well as approving any new competitions. So, with no further ado and much excitement, I cede the floor to Susie and Joy to advise us all about Susie's new handbook.
Okay, I just want to start off quickly with some thanks. On Zoom today, I know are several members of the Legal Writing Institute's Moot Court Committee, including Lane McFadden, who, as I will discuss later, reviewed a chapter of the handbook for me, which was wonderful and helpful. And the LWI's Moot Court Committee has been involved at various stages with the handbook. I'd also like to acknowledge my co-author, Melissa Love Koenig, who is on Zoom, and Joy will have a question or two for her later. Unfortunately, my other co-author, Jim Dimitri, of Indiana's McKinney School of Law, was not able to be here. He's actually teaching right now, and was not able to join us. And of course, I don't know if Linda Lacey, from Carolina Academic Press is on. Carolina Academic Press is a wonderful publisher to work with and published this handbook, as well as two of my colleague Diana Simon's books. So it's a delight to have worked with Carolina Academic Press.
Right. Okay, so by my count, you've actually written at least 2 books on moot court and a full-length law review article and several blog posts about moot court. So why moot court?
Why am I obsessed with moot court? Well, as a law student, I actually participated in the Jessup moot court team, and then as a 3L, I was their coach. So I have loved moot court ever since then. It was a great experience for me. Back then, there wasn't a really well articulated concept of professional identity formation, which of course now is very much front of mind in legal education with the changes to the ABA standards. But I certainly felt like moot court was indispensable to me in my own professional identity formation as a law student, and also just a lot of fun. But at the same time, because I've spent now, I'm trying to remember like what question comes next. Yeah, don't step on that. But
That's okay.
you're flexible. So also, you know, I've been coaching the ABA team for 15 years. I have a lot of very strongly held and well thought out opinions about what goes well with moot court competitions and what could be better. And so, for example, the law review article I wrote was in response to some things that I had observed in terms of reinforcing sort of a paradigm of how a lawyer should be that I didn't feel was constructive to students' professional identity formation. So, yeah.
Well, that actually segues beautifully to the next question, which is how did it come about that you started coaching the U of A moot court team?
So I wasn't supposed to initially. When I initially started working, I was supposed to just take over the 1L legal writing program. At the time, we were moving from a 1 semester to a 2 semester program, and my job was supposed to be to build out that curriculum. But at the time, we ended up, the person who had been overseeing the moot court competitions and the teams left, and it coincided with my joining the faculty. So I sort of picked that up, and I loved it, and so I just kept doing it. Yeah.
So you said, how many years have you been coaching the
15
team?
years.
Okay.
Yeah.
And anybody who follows you on Instagram knows that there's a fair amount of travel involved.
Yes. Yes.
So
So actually the ABA team just returned from competition and did very well. It was the regional round of the American Bar Association's National Appellate Advocacy Competition, where they argue a simulated argument before the United States Supreme Court. This year's issue was involved a dog sniff of some high school students for drugs. So it's a really interesting issue. And the teams did really well. I'm particularly proud that our team, one of our teams had the best brief in the region, which as a legal writing professor, I'm always extra happy, although I'm always happy if they're successful in any part of it. Of course, I'm extra happy that they won. They were recognized for their writing.
So this is the second edition of this text, but can you just tell us how the first edition came about?
So at the time, my co-author Melissa and Jim Dimitri, I believe they were co-chairs of the Legal Writing Institute's moot court committee, and I was a member of that committee. And we were at a conference, I believe it was the Legal Writing Institute's biennial conference, and we pitched it to Carolina Academic Press, who was there, was one of the sponsors of the conference, and there was nothing like this, and there still actually is no other book like this that is, you know, basically a beginning to end guide for how to start, run all aspects of the moot court program. And so obviously as a publisher, they're like, hey, there's nothing like this. We want to be the one that has this. And so that's kind of how it happens. And then, yeah.
So I noticed that the lead author is the Legal Writing Institute.
Yeah.
So that's kind of unusual. How did that come about, and why was it structured?
So one of the reasons that we wanted to write the book was as a source of revenue for the Legal Writing Institute. The Legal Writing Institute is the largest international organization of any kind, but it happens to be international, of legal writing academics in the world. And it needs money to run. It doesn't charge dues. And so they're always looking for different ways to raise money to run various programs. They do things like fund scholarship grants, have scholarship workshops. They do a variety of things to support both the teaching of legal writing and scholarship on legal writing. And they also engage in a fair amount of advocacy for legal writing professors, and it takes money to run those programs.
So how did it, just the mechanics of working with the Institute, with LWI?
So on the first edition, what happened was there were initially going to be 4 of us who were co-authors and editors. And then members of the Moot Court Committee actually wrote pieces of some of the chapters. And then as the authors and editors, we pulled that together and then wrote, whatever was missing from that. So in the first edition, for each chapter, there was a page that showed all the contributors for that chapter. And some of those included members of the Legal Writing Institute.
And was there already some institutional knowledge? I mean, had there been articles that you were able to draw on from LWI, or?
There have been a few articles, some written by, legal writing professors or other professors, some written famously by former Judge Kaczynski, who hated Moot Court and thought it was stupid. It was called In Praise of Moot Court Not. And so yes, we read all of those articles, particularly when we were writing the first book. And in fact, for the second version, I believe Professor Condit helped me update and make sure I captured everything that had been written since then.
Oh, great. A true team effort. So when you're writing this book, who is the target audience for it? What did you have in mind?
Primarily, we have in mind people running Moot Court programs, people who were coaching Moot Court teams. We probably more had in mind people who were new to that, because we all had been new to that at one point and there was no guidance for us, and we sort of cobbled together all that knowledge, and we thought, gee, this is something that would be really great if you were hired like I was and given this responsibility and had to figure out how to do it. We also had very strong feelings about what we felt needed to be improved, largely with external competitions, but also within. We had a very strong feeling about what best practices were, because, Moot Court, it is kind of a sport. I think Tony Young, who ran the Moot Court program at the law school where I went, UC Law San Francisco, she always called it sports for lawyers. And there is that aspect to it. But at its heart, it's supposed to be a fruitful educational experience, an opportunity for students to build their skills. And we had very strong feelings about how to enhance that aspect of a Moot Court competition or program.
Great. So how did you decide how to divvy up the topics, what topics to cover and who would write what?
I think a lot of it, we sat down, the group of us who were the lead authors, and brainstormed, and we brainstormed with the committee, and we came up with an outline of topics, from sort of an introductory overview. We have a chapter on, how to set up the program itself, the administration of a comprehensive Moot Court program. There's a chapter on specifically running an internal competition, a chapter on coaching teams, a chapter on starting your own external competition, where you have, you host a competition. And then in the second edition, there's now an additional chapter on matters specific to virtual competitions, which did not exist when we wrote the first edition back in, I think it was like 2015, when the first edition was published.
So, in reading this second edition, I noticed there are a lot of features of moot court, programs, competitions, and stuff that seem familiar. They were very similar to what we have here at the U of A, but there were some other things that were new to me. And so, how did you research this? Did you actually check out other schools' moot court programs, interview people, do some sort of survey?
Yeah, so there was a fair amount of crowdsourcing. We did draw on, as sort of the tagline of the book suggests, we did draw on the collective wisdom of the members of the Legal Writing Institute, many of whom were involved in moot court programs at their schools. We also, I think it's LSU collects a list of all the moot court competitions, and so we consulted that. So for the first edition, we did a lot of, talking to the people who were involved in the broader effort of writing the handbook for the Legal Writing Institute. And then also, there were some surveys that had been done and things like that we looked at. For the second edition, after 2020, or during the pandemic, there's a new organization that sprang up called the National Association of Advocacy Educators. The acronym is NALE, Legal Advocacy Educators, I think. And they had written up a best practices document that was primarily focused. Well, the organization is primarily focused on trial advocacy competitions, but it did have some things about movement competitions that we also consulted.
That reminds me of another question that I have. So where does moot court fit in the whole legal skills competition horizon?
Yeah,
or
so
umbrella?
legal skills competitions are kind of like the umbrella term. And within that, there's mock trial, which focuses on trial advocacy. There's moot court, which is strictly appellate advocacy. And then there are now a whole bunch of other competitions: negotiation, transactional, mediation. There's just a wide array, even some, sublists like intellectual property transactions. So there are a variety of different types of legal skills competition. Moot court and mock trial, there are the largest number of them.
Okay. But moot court, how would you describe that? That's focused on appellate advocacy?
Moot court is appellate advocacy. It could be before a federal, a mock federal appellate court. The one that I have coached for years is before a mock U.S. Supreme Court.
Okay. So, based on all of this exposure that you've had in your experience with writing this book, what would you say are the traits of an effective moot court program?
An effective moot court program has some sort of central administration. That's for a couple of reasons. One is to make sure that you're marshaling the resources of the school most effectively. If you have a bunch of independent teams that are working independently, you might be, drawing on the same volunteer judges. You might be, exhausting funds in a way that isn't the most useful. And you might also not be communicating opportunities to students and matching students with opportunities most effectively. So I think having a central, some sort of central administration like we do with the Legal Skills Competition Committee is very useful. I also think there needs to be strong student involvement as well as some faculty involvement. I don't think it's effective to have it wholly run by either faculty or wholly run by students. For various reasons. One is that the student body changes over every 3 years in a law school, and so you lose institutional knowledge that way. But also, I'd like to think that the faculty has something to teach along with, beyond what the students have to teach each other.
Yeah. So what about moot court competitions? Is there a wide variety? Are they all mostly structured the same? What's been your experience?
So they're generally somewhat the same in that there are, rounds of usually in a moot court competition, the first thing you do is write the brief. And then there are rounds of oral argument. Competitions vary though on subject matter. The one that I coach is anything that could be brought before the U.S. Supreme Court. So every year it could be a totally different topic. This year it happened to be a criminal procedure topic. Last year, it was a very somewhat obscure civil procedure topic as well as a intellectual property topic. And so it can just vary. One year it was a nightmare. It was like a cross between treaty law and insurance law, and it was incredibly complicated. And the difficulty when the law students can handle the complexity because they will focus their efforts, they will study. But the problem is you have to have a bunch of judges who also understand the complexities, and they only have so much time to prepare. And so when you have a really complex topic, the judging, I think, really sort of suffers. But in terms of the administration, I mean, you and I talked quite a bit because you coach PACE and I coach the ABA competition, and there are some differences in terms of whether you know that you won a round, for example. In PACE, you don't know if you won any given round, perhaps ever.
Right.
And I guess in the
No, you do
elimination,
know once you get into the quarterfinals.
Yeah.
And then
but in the ABA competition, you get to see your score sheet after each round. You know how each individual judge scores you, which I think is much more helpful, both for the students and for just the coaches who just kind of gauging where you are in the
Yeah.
competition.
So I think is it generally true, I know it's true with PACE and ABA, but that the students can get no outside help on the brief writing, which is why when they win best brief, it's so satisfying as a coach. You can't take any credit for it, but you're just so proud. And I have to say, PACE last year, our team won best brief.
Yeah.
That was very exciting.
Yeah, it is very exciting. One of the really great things about Moot Court is the fact that they do have to write the brief. I mean, there's a team of 3 students in the case of the ABA team, and the PACE team actually.
Yeah.
In other competitions, it's teams of 2 sometimes, or in Jessup it could be 6 students. But they're doing it without any help from faculty, from practicing lawyers, from anyone. There are pretty strict rules about that. So.
But now when it comes to the oral argument piece of it,
Yeah,
that's no longer true, right?
So for oral argument, for most competitions, I believe actually there might be 1 or 2 competitions where they can't actually get any help with that either, that preparation. But the vast majority of competitions, once the brief is in, the students can have faculty coaches, help them prepare and help them fine tune their arguments and probably take full advantage.
Yes, we send our team members out to meet with faculty, so maybe some people have been hit up here.
Yes.
Especially for environmental law, it's great. It's a great resource to have environmental law professors. But you've had, so this year you had a criminal.
It was a criminal procedure issue.
Yeah. So you were able to.
Dean Miller helped, Professor Lott helped. We had it's because it involves schools. It was great to have Professor Newmark come in and talk about it from an education perspective. It was really extremely helpful to have discipline, or Professor Woods, Jordan Woods. It was really helpful to have people with specialty in the discipline come in, as well as we had a number of our past team members, I think about 14 alumni who had been on the team in the past, who came in and mooted the students in 1 or more rounds. So that was incredibly helpful because they're all, a heartwarming number of them are actually currently appellate practitioners, and were able to come in and talk about their own appellate practice experiences and give feedback from that perspective. And even those who they're all litigators to some extent, even those who hadn't been arguing in appellate court were able, brought in information from their own practice. So.
Yeah. And I always find, I'll just add as a coach myself, it's really helpful to have the doctrinal faculty kind of reinforce that, you're understanding this stuff as correctly as well, because I'm not practicing in that area anymore. So
that's always reassuring.
Yeah. So keep up the help, please.
Yes.
So what would you say is special about the U of A's Moot Court program?
Aside from the obvious, which is that we have the best students. I mean, that's a whole lot. But I think the fact that one thing that I think is special about Arizona law in general that extends to the competition teams is we have, for a small legal community in Tucson, we have an incredibly involved alumni base. It is startling. So, for example, I went to we went to the regional round of the ABA competition in San Francisco. San Francisco has a larger legal community by quite a bit than we do here, but they really struggled to get attorneys to volunteer to come judge, even though there were several San Francisco schools that were competing. We have very little problem staffing, not just the benches for our internal moot court competition, but also getting people to come in and moot students for our various competition teams. I almost always, we had, I think, 10 or more practices, and at every practice, we had at least 2, if not 3 or 4 outside judges who were there to help with the students. So that's a really special thing. Another thing that's really special about our program that, again, is not unique to moot court, but is special to Arizona law, at least based on my experience, is that the student body is incredibly collaborative and supportive of each other. And that makes it almost inevitable that the teams will be like that.
Yeah.
That they will be incredibly collaborative and supportive, which when you have to write a brief together over winter break, when everyone's tired after exams, it really helps.
Yeah. It's interesting because my team this year is still telling stories about they say they spent 8 hours locked in a room together, like doing the final proofreading on their brief. So
And
it
it's
was
good
a bonding
experience for
moment.
practice because I've definitely had those experiences in law practice as well.
Yeah. So you mentioned before when we were talking about the legal skills competition umbrella, that we've got the 2 big components, our trial team and moot court teams. Is there a rivalry between those 2 actions?
There a little bit is not here, of course, but yeah, I mean, to some extent, if you're wanting to build a good team, you are sort of competing for some of the same students. I mean, students who are interested in litigation are going to want to do probably some sort of legal skills competition, and but the moot court requires you to also want to do a lot of writing. And so that definitely is a little bit different. But I've had students who did both. I mean, I had students who were in the same year going to nationals with our trial team and then turning around and competing on the ABA team and being incredibly successful in nationals as well. So they're not mutually exclusive, certainly, although there is only so much time to devote to.
I mean, I've had similar, not necessarily trial team, but I've had students on the environmental moot court in their 2 year. Then they do vet leave when they come back because we're done by end of February, and then they, of course, they're so outstanding as oral advocates. They end up making the ABA team, and then in their 3 year they do ABA moot court. So
and then we have to compete for them when we want them to come back in university.
Yeah, that's true. We do compete. Always competition with lawyers. So, okay. So, what was the favorite part of your favorite part of writing this book?
Well, I mean, it was fun to collaborate and to see what other people's thoughts were on something that I had strong thoughts about. But I was fortunate in that I got to write the first chapter, which is sort of the why do moot court, why have a moot court program, and also the history of moot court, which when I told you this yesterday, you're like, of course, you're such a nerd. But I really enjoyed researching the history of moot court and how it came up through the through the Inns of Court in Britain and how it
Harvard.
How it came through legal education and how it sort of fell out of favor for a while, especially after.
What was it? The faculty mooted that like held
weekly moots at the beginning. Yeah, when Harvard first started, before we got to the sort of casebook method that dominates or has dominated. A lot of it was done through mooting students through various legal problems. Yeah.
So, if somebody already has the first edition, what's different about the second edition? Why should they pick up the second?
So the biggest changes to the second edition are, I mean, there's a whole extra chapter, which is on virtual competitions, and it shares what was the best and most complete advice we could provide on how to, organize a virtual competition, whether internal or external, and how to coach students through that process. And then we also added between 2015 and 2022, which is when we really got going on the second edition, the ABA standards changed. They added standards requiring experiential education, 6 units of experiential education with a simulation class option. And so there's advice in here about how to have your moot court simulation class meet those requirements. There's also more on accessibility for students with disabilities, and there's some on diversity, equity, and inclusion.
So you were the lead author on the online or virtual competitions. So what was your strategy for preparing to write that chapter?
Well, I had been involved, so I mentioned NALE, the National Association of Legal Advocacy Educators, and when that organization first started during the pandemic, I was involved heavily in it. And so I had been involved in discussions about best practices and learned a lot from that. And then Tessa Dysart, who at the time was running and for 5 or so years has run the Fedsley competition, maybe 7 years.
Some people might not know what that is.
So the Fedsley competition is our internal moot court competition, where students within our school compete against each other. There are also external competitions where students go out and compete with students from other schools. But our internal moot court competition, which I ran from 2010 to 2017, then when Tessa came on board in 2018, she ran it until this year. But she was running it during COVID. And so she had to, like, literally, I think my ABA team went to the regional in Oklahoma City, came back, the world shut down. And so then Tessa had to pivot and move our internal competition online. And she wrote quite a bit about that on her, the appellate advocacy blog that she runs. And so I cited quite a bit of her advice and the anecdotal stuff for what we actually did. But I also did a lot of research about what courts have done in terms of virtual oral arguments and what they say about best practices, and what other schools had done in terms of best practices.
Yeah, case went online.
Yeah.
So I came back from the 2020 competition, same experience as you with Oklahoma City. Everything shut down, and then the next year it was online. And that was a very different experience. But
I actually interviewed, we had some students who were actually, I believe, they were about to go to their competition. And that was it was the Giles Rich intellectual property report that literally, like, over a weekend pivoted and went online. And so I interviewed them about their experiences and their thoughts, and I included some of that as well.
Great. So great. So obviously the trend has been, I think a lot of moot courts stayed online for a couple years. I know Pace did, and then just last year went back to in-person. But there have also been new online moot courts. So that's kind of been a trend because it's, as you mentioned in your chapter, it's cheaper. Yeah.
I mean, it's a great opportunity. I know our trial team goes to at least one virtual competition as kind of a dry run for the in-person competition. I think that's a great idea. And for a school that wants to host a virtual moot court competition, the cost is much less. And for a school that wants to send an extra, get a team extra experience, the cost is much less. It's a very different experience in a lot of ways, but the skills certainly do transfer. And you and I both have taken advantage of what we've learned from that to integrate virtual practice sessions so that the students get more practice and we're able to draw in alumni from who don't live in Tucson.
Yeah, some of the old team members, were on the big screens in the moot courtroom the other night for my practice. So yeah, all of those things, we used to just feel like we had to get people who were in town who would be willing to come
And
to
it's, you know,
practice.
it's better because of the competition itself. I mean, one of the things we talk about in the book and that Melissa talks about in her chapter is it's so important to have several practices where you're doing it in the same. I mean, I remember, and everyone's different, but I remember when I would be preparing for an oral argument, I'd be totally confident about the substance. The things that would trip me up or where do I stand? Those are the things that would like really give me anxiety. Is what's it going to be like? Where are the judges going to be? Where am I going to get in trouble for being in the wrong part of the? I don't know. So I always went to the courtroom the day before, or you know, came a little early and watched maybe Law in Motion Day just so that I would have a little comfort level. And so it makes a lot of sense to me. And all of the best practices advice says have as many practices under real competition conditions as you can. But you know, there's only so many. There are only so many past team members who are still in Tucson, so it's nice to be able to draw on those who are
Yeah.
not. Yeah.
So in addition to kind of the trend to maybe more online or more hybrid, are there any other trends you're seeing in the moot court world?
I mean, I think I'm not sure if this is a trend, but I'll tell you something I've noticed, and I'm not sure why this is happening, although I have some ideas. I've noticed, so at a moot court competition, generally they have to recruit lawyers and judges from the local community to come volunteer their time to pretend to be judges to moot the students in each round. And it used to be, and tell me if this is, I think this is what it's like at PACE as well and other competitions, that the students would argue and then they would get in-person oral feedback from the bench about their performance. And that feedback used to be lengthy. And I've noticed lately that over the years, the judges have been less voluble in their feedback, less specific in their feedback, and lately not wanting to give any critical feedback. It's all very like, you're great, you're better than all the lawyers that I see before me, and I'm pretty sure that's not true. Although I do think, based on my own experience sitting in the back of courtrooms, it's true of some, but so I'm wondering if the competitions have said, you know, don't say this, don't say this, don't say this. And then the judges are afraid to give any really critical feedback, which maybe isn't the best.
Yeah, yeah. I haven't seen it. We'll see, because I'm leaving on Wednesday to go to this year's PACE. But yeah, I mean, sometimes, and we've talked about this, sometimes the feedback the students get from the judges that are recruited isn't necessarily feedback we would agree with.
Right.
So that's always a challenge.
And that's why it's so important. And I'm so grateful that Arizona law allows the coaches to go with. There are teams that just go by themselves. And so the students are forced to sort through everything on their own and decide for themselves whether the feedback is worth listening to. You know, I at least can, you know, talk to the students afterwards and say, well, you know, that one I don't necessarily think. I think that's that particular judge's, you know, feeling, and I'm not sure that, you know, that's feedback that you should generalize to your whole life going forward.
So have you seen a change in the level of participation over the years?
I think it kind of goes up and down, depending upon the interests of a particular class. And, you know, obviously with our class sizes going down, generally there are fewer students participating in everything. But you know, from year to year, the number of students who are interested in competing definitely varies.
Yeah. Any changes in the makeup of the team?
Well, I mean, it just varies from year to year. There was one year that I got really worried because only male students were trying out for moot court, and I was like, "What's going on? This is terrible." And then this year, I had only one man on a 6-person team, so I think it varies a whole lot.
Nothing you can really read into that.
I don't think so. I mean, I worried that there were reasons, but then it fixed itself. So I don't know.
So what's your favorite part about coaching moot court?
Oh, I mean, you spend a lot of one-on-one time with the students, and any one-on-one time you spend with students at Arizona Law is always wonderful. And I also really love that I am in touch with the majority, well over 50% of the team members that I've coached over the past 15 years. When I travel for conferences, I'll meet them for coffee or lunch or dinner or drinks or whatever. When they come back to Tucson, we'll meet up and talk. I get to follow their careers. Again, many of them are actually appellate advocates, working in various areas.
I had one of my former team members who was also on the ABA team tell me a story. He was helping out at practice the other night, zooming in from DC, and he told me that he had been arguing. He'd been out, I think he was in Washington, arguing in federal district court, and there was another attorney on the case who looked at him and said, "Did you do pacemaker?" And she totally remembered him, and they had made it to the semifinals. They'd been a very impressive team, but yeah, and he was an excellent advocate. So yeah, it's very satisfying when that kind of thing happens.
Yeah. It's also really satisfying. I did not get to experience it this year, but in the past, my teams have beat my old coach's team, so that's always really
Okay, well, so now I have a question for Melissa. Are you there, Melissa?
Hello,
Yay.
I am. Can you hear me?
Yes, we can.
Great.
So this is Melissa Lepsoda. She's at Marquette, and
Hello.
she was my co-author on both editions.
So my question for you, so am I looking in the camera? It feels weird because you're behind me, but I'm gonna look
That's
at
okay.
you. So you wrote the chapter on advising external competition teams. So what would you say is the most important takeaway from your chapter?
Well, thanks for the question, Joy. I am going to piggyback off of the previous comments about the interactions between the coaches and the team members, especially when we have coaches coming in who are alumni of the Moot Court program at a school. I think that the professional identity formation for the students in terms of working with local attorneys, as well as the teachable moments that the local attorneys have with those students to come back and mentor them and to share their expertise is very important. And I think that's one of really the very best parts of the Moot Court program is building those networks, building the professional competencies through a variety of sources, including those practitioner coaches. The other thing I wanted to highlight about that chapter is that it talks about forming teams, selecting teams, which I think is one of the most challenging aspects of working on a Moot Court program. And for instance, selecting teams out of the first year class versus selecting teams out of the 2L class and how to go about doing that. So the chapter talks about that, and I think that's useful.
So one of the things you talk about in your chapter is the notes versus no notes debate. And I want to know, what camp do you fall in?
I love that question. I was literally just talking about that with one of my students yesterday, and I was pondering that, so I was delighted to get the question. I think that's a tough question because it might really depend on the judge's perspective, and you don't really know what their perspective is until they start to comment about your argument or the student's argument when they are done. I think I fall down on the side of it's okay to bring your notes up to the podium. I think if a student doesn't bring their notes, it can really wow the judges. But if they seem like they don't know their argument as well, or if the judge just thinks that that's not realistic in practice, they might get dinged on that. And I've seen students get that feedback. So I'm really interested to hear what you all say about that, because I think it's a tough call. I think there is the wow factor, but I think going up with a few notes, not too many, is probably my preferred advice.
So Susie, how about you?
I am an ardent no notes person. I would never give that advice to someone in practice. I definitely always took notes with me. In fact, I took my binder with me to the podium. But in moot court, the problems are designed such that you should be able to know everything well enough. And notes, even when, okay, I said I took that binder up. I think I looked at my binder and all the arguments I did. I think I looked at my binder once, and that was because I wanted to tell the judge exactly what page of the deposition some testimony was on, and I wanted to point to that testimony. But every other time, I mean, an oral argument is a conversation between the advocate and the judge or judges. And generally, in moot court, it becomes more of a burden than a help. It becomes an excuse to break eye contact. It becomes sort of something that you fall back on when you don't need it. You think you need it. So I usually force the teams to go off notes 3 or 4 practices before the end, and then I assess what I'm going to advise them to do at the competition based on that. This year, every member of the team went up without notes. They never felt like they needed them because it was such a robust conversation with the bench, and they knew everything so well, down to page numbers on the record on which testimony appeared. I mean, unlike in a real appellate matter, their record is relatively manageable, right? You're not talking about thousands and thousands of pages. You're talking about a relatively manageable method. So, and they know this year it was a very small universe and as well. So there was no reason really that they would need to look at their notes. And that generally I noticed in practice, the notes were really holding them back rather than helping them. So I do definitely think, though, as Melissa says, it's a judgment call. But I have had advocates who definitely got better scores because they went up without notes. I also have advocates who stumbled because they weren't prepared, not because they didn't have their notes. And the judge might have said, maybe you should have brought your notes, but I'm not sure the notes would have helped. So, yeah.
So recently I had a student who's still here in Tucson come for a practice and be a practice judge. And he reminded me of something that I had told him, which you always love to hear that students actually remember anything that you tell them. And he told me that he said, Professor HC always told me the hardest question you get should be in practice. Are you a mean practice judge, Susie?
I don't have to be because sometimes Sylvia is for me. No, but the other, it's really kind of sweet because I have people who've been coming back to judge practices since they were students in 2010. So I have one particular former student who makes it his job to ask the off the wall weird question because he personally got off the wall weird questions. I have Ashley and Zeke, both of whom are appellate practitioners at a very high level, who are extremely rigorous practice round judges. So occasionally, if I know that there's something that, because I'm at every practice, they just parachute in for a practice here and there. So if I know there's something that a student needs to be pushed on, I will do that. But otherwise, I let other people be the bad guy.
No, you're the good cop.
I get to be the good cop.
Yeah, there have been times. I remember one time I was looking at Zeke and I asked him some really hard question. And I just looked and I said, you want to kill me right now in your heart. And he did not deny it. No. Well, anybody have any questions for Susie or Melissa?
Yeah, Diana.
2 parts unrelated to each other. Asking for a friend. When you write a book, how does that second edition come about? Does CAP reach out and say, we want this, or do you say it's time?
So in this instance, CAP did reach out. The timing, so the first edition came out in 2015. The contract said in 5 years, we'll see, and that was 2020. So we were a little delayed in getting the second edition done because of, I don't know, the world being on fire again. And us, everyone involved is the legal writing professor who had to pivot and change everything they were doing and didn't have, the time, and we're kind of doing other things that were more responsive to what was happening. But that, and then we sat down and assessed, Jim and Melissa and I, what needed to be updated. And I'd already had some thoughts because of what was going on at the time with the virtual competitions. And there were some other things that came up over the intervening years that we kind of made notes of as they came up, that we maybe wanted to add. And then we also consulted the members of the ADA, the LWI Moot Court Committee, if they had any suggestions.
Okay, and then part two, I was a note card oral advocate. I actually handed out I could say, this is a note card. They apparently do know what it is. But I get more and more requests, it seems like each year, even in the 1L argument, to bring computers up to the podium, which I say no, because of eye contact, and I think what's your opinion on that?
I would say definitely not a laptop, because you don't want that screen up. I've had, the very first year I had a student argue with an iPad, it backfired on him because it was glitching out. The nice thing about paper is it doesn't glitch out on you. Battery doesn't die, it doesn't, reboot in the middle of your argument. So I am a physical note person if you're going to take anything out. But
did you see any students in the competition?
No.
Okay.
Any students who brought notes to the podium brought basically a folder. So the University of Missouri, Kansas City has a famous folder method video. Those of you who've been in our 1L class are familiar with that, where they recommend that. And I think a lot of the Moot Court teams use that. Yeah.
You try to focus the students to any degree on ethical issues that they may confront in this area?
Occasionally the problem implicates them. And, we definitely talk about ethical issues that are implicated in every time that you write a piece of legal advocacy, things like addressing contrary authority, about making arguments that are well supported by authority, diligence, competence, things like that. So those come up with any Moot Court problem, and we do talk about those. Sometimes the subject matter of the problem also implicates other ethical issues, and we definitely address those as they arise and they come up. Yeah.
You'll give us a couple of examples.
Well, an example would be, how to deal with contrary authority, which is some of which we cover in our program. And I would just remind them, the students, of the duty to disclose that authority, the duty to of candor to the court, and we talk about how to deal with it in a way that's persuasive while also being honest. So that would be one example.
That actually reminds me of something that I guess I wouldn't have known when I was in practice, but occurs in court, which is the teams have to argue both sides of the issue. And like in the Moot Court, they have to argue on behalf of all three parties. So they really have to deal with, the competing arguments, but that also sometimes will raise by, implication, some of the ethical issues of, because the issues so well, you understand the nuance of what you can really argue.
And there's another example which ideally would not come up. It has not come up with one of my teams, but so this was a criminal procedure problem, and someone said something about how in one of the cases about the defendant didn't testify or something like that. And I was like, oh, and it was a team that had come without a coach. And I was thinking, well, that student could really use some coaching on the fact that the defendant doesn't have to testify, and that, that there's probably a good reason that the defendant didn't testify. So that was one example, but yeah, those are the ones that come to mind.
Any other questions?
Yeah, Angie,
A question. So when you talked about transitioning from writing the brief to oral argument practice, I'm just curious. So it seems like the brief is locked in. Is it unchangeable at that point?
Yes.
Okay. That's just custom.
Yeah, so, and also, a lot of competition, a lot of the, external competitions, and I believe we've done this with Beckley as well, sometimes in the past, although now that it's so closely tied to the LW class, we don't. But in the competitions, you can read the other side's briefs. But then you get there and you realize, oh, they've learned since then. They're not arguing the same thing. And that's very unlike the real world where you wouldn't be able to bring up a new argument that you hadn't briefed, right?
So your brief score follows you into the competition. So doing well on the brief really positions you great for the oral rounds, but you are not locked into the arguments. The judges who you're arguing before didn't necessarily read your brief or understand what brief you filed or what you argued in your brief. So it's fair game. And one of the fun things, I don't know if this is true with ABA, but at PACE, we're sitting there. So our first round, we're representing one of three parties. And if we hear good arguments from the other people, the advocates, we can totally steal them for the later rounds. You know, we can be very nubile.
The point of it is to learn, right? And so if you're learning, oh, that's a really good strategy. I hadn't thought about that.
Yeah.
Could you guesstimate for students who are interested in becoming involved, like how much time is this on top of their?
So, I think that really varies. I mean, to do a good job on a record of average rigor, like not one of the really obscure problems, you know, they spend most of winter break working on it, you know, at least a few hours a day. And then for practice, you know, for the oral argument practice, I think we were practicing formally, at least 3 hours a week. And then, that doesn't count like the informal, practices and the, you know, back and forth that were happening. So, and actually, that's an understatement because the practice, so probably about 6 hours a week when you consider the time for feedback and everything. So
You do get credit though. You do get credit for
most of
report.
the Arizona Law Moot Court teams get some amount of academic credit depending on the workload.
It's not graded, is it graded?
It is not graded.
But if you talk to students who have done moot court, I think they would unanimously tell you it's just an amazing experience. It's on multiple levels.
I felt like it captures some of the things that are most fun about being a lawyer. You're collaborating with other really smart people on solving the same problem. That was always my favorite thing in law practice, was to walk over to my colleague's office and talk through, you know, whatever I was trying to research or write, or you know, recapping a deposition or things like that. And that I think is a really fun aspect of moot court.
So on the flip side to that question, how much time would you tell a new advisor they should take to prepare to be an advisor?
Oh, it's a lot of time. When the problem comes in, you know, you have to spend time to read it and do some, you know, basic research, especially if it's an issue that you don't know very well or it's a difficult issue. And then, I mean, personally, I think it's a best practice for me to attend every practice, so that I can give people feedback and guide them and not have each thing be, you know, to be able to learn from the whole thing. Recruiting judges, you know, just going to the competition alone is, you know, 4 days, 5 days. So yeah, it's a substantial time investment.
We only have time maybe for one more question, if anybody has any. I haven't seen any in the chat, but I do welcome you once again.
And definitely the students who are here because you're doing Fegfully, if you have any questions, I'm happy to answer.
Well, apparently you both were too thorough.
And Melissa, thank you so much for
I
that.
just would also like to give a shout out to anybody in the audience who hasn't been involved in the court, particularly if you're a member of the faculty and you want to help us out. We are always looking for practice judges. You know, it's a huge help. I really get tired of hearing my ornery question.
Well, if we could give a round of applause. Thank you both. Thank you all for attending. I hope you have a great rest of your day. And